That is unfair to her. It puts her in the middle, and it is, of all the things that we've talked about today, the thing that gives me the greatest concern. If that happens again, contempt is in your future. Good afternoon, everyone. We are here on case number FB11. If I may have the party's appearance, please. Mr. Meador, why don't you go first?
Thank you, Your Honor. Shawn Meador, the parenting coordinator.
Thank you. Ms. Would you state your appearance for the record? Give me your name first. And Ms., can you tell me the county and state you're appearing from, ma'am?
Washoe County, Nevada.
And ma'am, is there anyone else with you in the room?
No.
And do you agree to going forward using Zoom?
Yes.
Thank you. Mr. You, sir, could you give me your name?
Yes.
And Mr. County and state that you're calling from?
Washoe County, Nevada.
Mr. Can I ask you to please find a place and be stationary?
Yes, I'm getting set up right now.
All right,
Yeah.
Thank you, sir. I ask that simply because when you're moving, it makes me seasick.
I apologize.
Sir, is there anyone else in the room with you?
No, Your Honor.
Thank you. And sir, do you agree to going forward using Zoom?
Yes, Your Honor.
Thank you. We are here with regard to the parenting coordinator's recommendation number 17, which was approved by the court. I will note that in addition, Mr. has filed a notice of completion of his previously ordered community service. And the court notes that community service requirement has now been disposed of and completed to the satisfaction of the Washoe County School District. Do the parties wish to say anything about that?
No.
Then, thank you. Then we are here. We have recommendation number 17. And that recommendation seeks an order to show cause, which was issued by the court, for them to demonstrate why she should not be held in contempt for various matters. Mr. Meador, would you like to elaborate on those?
Yes, Your Honor. Preliminarily, since the recommendation in late August, from my perspective, things had been quite quiet. I had not been barraged by emails from the parties, and I was hopeful that that would signify that things were going better. I'd also noted in recommendation for order number 17 that if the parties engaged in counseling, in co-parenting counseling, in an effort to see if they could do a better job of co-parenting, that I thought the court should take that into account in evaluating any concerns that I expressed in recommendation number 17. I learned in the lead up over the last couple weeks that the parties have engaged in some mediation counseling that Ms. reports to me has been helpful, that Mr. As always, finds a reason to point the finger of blame at Ms. that he is the good parent and the good guy, and she is the bad parent and the bad guy. It has been a constant theme throughout this process that has been unrelenting and is unhelpful. At the time, so I provided the court with two possible exhibits. One exhibit is that I reached out to the parties, and I've basically explained it's not my goal to punish people for the sake of punishing people. It's my goal to give to co-parent in their daughter's best interest and to stop putting their petty little power struggles before their daughter's best interest. So I asked them both to outline for me what they thought reasonable solutions were to the concerns I raised in Exhibit 17. And to his credit, I think that Mr. responded quite thoughtfully, acknowledged concerns that I had expressed, and at least verbalized a willingness not to engage in that behavior. I was disappointed with Ms. response in that it seemed to fail to really acknowledge or recognize her role in all of this. And, you know, we don't, as human beings, tend to do better unless we can acknowledge our own role. The facts are set forth in the recommendation that had been approved by the court. The second exhibit I attached was the text exchange between the parties on the day of the incident that brought this to a head. And I think the court, if it reviews those communications, will see that neither party acted optimally. Since
Mr.
then,
Meador, would you like to offer those exhibits?
yes, I would offer both exhibits, Your Honor.
And Mr. Do you have any objection to Mr. Meador's exhibits A and B?
No, ma'am.
Do you have any objection to Mr. Meador's A and B?
I do, Your Honor, for two reasons.
Okay, which exhibit, ma'am?
So both of them.
Okay, and what's your objection?
Both of them for the reason that I haven't had time to read them. One was very lengthy the other one was filed this morning. And I haven't had time to look over it or find the actual text messages, the original ones that didn't have anything deleted and deleted text messages out of those. So I don't think it's accurate, giving an accurate picture.
So your objection to exhibit B, as I understand it, is that it wasn't filed in a timely manner and that you believe it is incomplete.
Yes.
And with exhibit A, simply that you haven't been able to review it?
Yes, Your Honor. Because
Okay.
it's so long. It's 23 pages and it was filed this morning.
Exhibit
Yeah,
A, no, exhibit A
she's
was not filed this morning.
She's confused, Your Honor. Exhibit A is her own email to me dated January 23rd. So she's, I assume, familiar with her own email to me dated January 23rd. The second exhibit were copies of the text messages that were provided to me in August. And while Ms. suggested that they had been altered, I was never provided with any documents to show that they had been altered. Even if they are incomplete, they show both parties taking positions and using language that's inappropriate.
I am overruling the objection with regard to exhibit A. simply because that objection didn't reflect any legal basis for the court not to take a look at that exhibit. With regard to Exhibit B, I am going to sustain the objection because the exhibit was offered this morning in advance of this hearing. So, but Exhibit A is certainly in.
So,
And we have, I think we have in Exhibit A, and I'm pulling up Exhibit A now. And in Exhibit A, it appears that Ms. Agrees that she used rude and disrespectful language, and she has basically committed to not use that language any further. At this point, Mr. Meador, I have to find that there is an order, that the order is clear and understandable, and that the party who is committed to action under that order is capable of fulfilling that action. Can you point me specifically to the order that you believe has been violated? And recommendation 17 obviously can't be that order. It would have been an order prior to 17.
I believe that I referred to all of the recommendations in the body, in the specific findings of recommendation number 17, Your Honor. With respect to each finding of fact, I referenced the specific recommendation.
I know you referenced the specific recommendation. Do you have a recommendation number for me?
Well, yes, recommendation number 3, recommendations 1, recommendation. As I went through my specific findings of fact, I specifically referenced which recommendation number was called into question. So they're all in recommendation. They're all referenced in recommendation number 17.
Thank you.
So again, the recommendation number 17, I found concerns with both parents' behavior.
And you recommended in 3 separate places modest sanctions for Mr. activities.
Right. It's not, neither of these parents have a great deal of financial resources. They have children to support. The being fined troubles me that fines adversely impact their ability to care for their children and put food on the table. And yet I have essentially no tools in my toolbox to convince them to read, pay attention, and follow the recommendations that have been approved by the court to protect their daughter. And so I'm at a bit of a loss to how to get their attention. They both still remain focused on blaming the other, focused on hyper counting of minutes that they've been deprived with their daughter, of blaming the other, of finding fault with the other, and ignoring how their behavior adversely impacts their daughter. Just in this last round of email exchanges preceding this hearing, Mr. raises for the first time an issue about Ms. again being the victim of domestic violence. This is something that he's raised throughout, consistently, regularly throughout the time I've been involved, and always in connection with blaming Ms. He's altered his language a bit now to suggest that it's harmful to their daughter. And yet it still comes down to blaming Miss and that she was a victim of domestic violence. And this just constant obsessive need he has to project to me in the court that he's the good parent and she's the bad parent, when it's my very clear opinion that both parents have strengths and both parents have weaknesses, and both would be better served and their daughter would be better served if they focused on their own behavior rather than the other's behavior. So, specifically on the contempt, Ms. failed to read the Our Family Wizard message. That Mr. was running a few minutes late. She took off before he could get there. She used her daughter to convey messages directly contrary to my recommendation and used rude and disrespectful language. It's somewhat ironic that she was upset that he was running late when the evidence presented to me was that she had been late on quite a few occasions. She had notified Mr. that she was going to be late. My concern was whether she was late so often she wasn't making reasonable efforts to be on time. On the other hand, Mr. complained about her being late, even when she was only 2 minutes late. I don't find it reasonable to make a complaint about someone being 2 minutes late. Ms. claimed that she didn't read Our Family Wizard because she had lost her phone and couldn't find it, so couldn't read the Our Family Wizard message. But then, essentially immediately after she left, her daughter's using her phone to text Mr. And when I asked her, well, when and where did you find the phone? She couldn't provide any answer. And therefore, that's why I found that her explanation for not reading Our Family Wizard did not seem credible. Those were the concerns. I've told both parties repeatedly, and it's in recommendations, do not use your daughter to convey messages, and do not come to me and make claims about the other that are based on what he has allegedly said. And yet both have continued to rely on what he says more frequently, and Ms. clearly used their daughter to convey messages contrary to my recommendations. She just simply has to find a way not to do that and not to put her daughter in the middle. With respect to Mr. He's simply unrelenting. He's asked over and over and over again for the holiday schedule to be changed. I've advised him over and over again, I have no ability to do that. I could make a recommendation if he provided me evidence of a change of circumstance, and that based on the change of circumstances in best interest, and yet he continues to raise it. I very specifically recommended to be allowed to participate in gymnastics, and he asked that she be removed from gymnastics, again, without showing a change of circumstances or that it would be in her best interest.
I actually have an independent recollection of that particular hearing.
And I did agree. I did agree to modify to allow him to find a more convenient time on his schedule for his family for her to participate, but that I wanted her to remain in it. There was also an odd email to these therapists that just said stop. Ms. says that somebody else has her phone number and somebody else was texting the therapist to stop. I have no way to evaluate other than this is the therapist we agreed would treat. I made it very clear I wanted in therapy, and that it, in my opinion, the parents each had an obligation to make sure that their therapist had correct contact information. I then finally wanted to prevail upon Mr. that he is not allowed to speak for me. He has a pattern of sending texts in which he threatens, in effect, to sick Meador on her, or Meador's going to do this, or Meador's going to do that. And I'm not comfortable with him purporting to speak on my behalf or use me as a weapon. My goal has been partially accomplished. I wanted the parents to participate in co-parenting counseling. The reports from them about the success of that counseling and how often it's happening are not completely consistent, but at least conceptually it got put in place. And I'm hopeful that with continued co-parenting counseling, they can move off this historic pattern and focus on their daughter's best interest.
Mr. Meador, do you know is currently engaged in therapy?
I'm told she is. I admit I don't know how frequently. I believe Mr. told me that he and or his wife take her and wait in the lobby while she's in the therapist sessions. I don't know if that's just during his custodial time or if that's all of the times that he's able to go. I do know that Mr. has been supportive of being in therapy. And I haven't seen evidence of him trying to sabotage that in some way.
Okay. At this juncture, I'm going to ask the parties to raise their right hand for me.
Do each of you solemnly swear the testimony you're about to give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Go ahead and put your hands down. Ms. Johnson, you have heard Mr. Meador's recitation of his version or his understanding of the facts. Now is the time for you to be able to tell me why contempt isn't appropriate here. And I have a first question, which is he still in therapy?
Yes, ma'am.
And are you taking on your time?
Not as often. There was an issue, if you'd like me to elaborate, that caused that, but I don't take her as often, but I do take her.
Are you taking her the amount of times that the therapist is requesting?
Yes, ma'am.
Okay. Are you talking to the therapist so that you know how he is doing in therapy?
Yes, ma'am. She texts me, she calls me.
And you're able to communicate back with her?
Yes.
I heard the explanation from Mr. Meador with regard to why there was a text that says stop. Can you tell me what phone number that text went to?
I believe it went to my old number, which was 775, which is, I'm under the impression it's a business now. I'm not sure which business, but I had that phone number for a very long time, and I'm sure they're getting a lot of texts, a lot of phone calls from people who should not be calling them and texting them, and they probably are pretty irritated about it.
And do me a favor, just give me the last 4 digits because this information is it's in the record. Just give me the last 4 digits of the phone number you're using now.
6955.
And how long have you had that new number, ma'am?
I would say probably about a year.
And did you supply the new number to therapist?
I did before that happened, but they
Okay.
must have accidentally texted the old number.
Now, once there was this miscommunication where the old number is texted and the business text back, stop. What did you do to try and ensure that he was in therapy still?
That was a while ago. I don't remember how I found out about it originally. I think that might have talked to me about it, and that's how I found out. And then I texted the therapist to let her know that that wasn't my number, and then I didn't send that to her, and I made sure that she had my number, and that hasn't happened since.
And were there any consequences to, therapy? Was it interrupted in any way because of that text?
No.
Ma'am, the remaining issues involved in Mr. Meador's request for contempt involve recommendations number 1, number 2, and number 3. And they really are dealing with number 1, not looking at our family wizard. Number 2, using your child to convey information to her father. And also using rude and disrespectful language with her father involving, I believe, this incident. Can you tell me, was Mr. Meador's understanding of that incident and what occurred in error?
Yes.
Okay, in what way?
Can you, I'm sorry, can you repeat the 3 issues that you wanted me to elaborate on? Not reading our family wizard.
Number 1, you didn't read our family wizard. Number 2, that you used your daughter to convey information to her father. So used her as a go-between. And number 3, that you used rude and disrespectful language with her father with regard to this incident.
Okay.
So tell me why that's wrong.
That's wrong because as far as the contempt goes, I was not willfully disobeying the order. I had, with the our family wizard messages, I had lost my phone, and then we had I didn't want to be late to the exchange, so I left my phone here instead of looking for it. So I wasn't aware that he was going to be late. I have a special needs child that has ADHD and developmental disorder, and so he was having a meltdown and he was running around the parking lot. And so first of all, I wasn't able to read the Our Family Wizard messages. And so I wasn't aware. It may sound silly, but I wasn't aware that she wasn't allowed to call her dad and ask him where he was. I didn't think that was contempt. I didn't think it was against any orders. So I said, go call your dad and see where he is. I wasn't trying to hurt her, put her in the middle, but she did call him. And at the point that she had called him, yes.
Can I stop you for a second? How did he call her father?
She went into the Mavericks and used their phone.
Okay.
And she
go ahead, continue. I interrupted you. I apologize.
Oh, it's fine. So he told her, she told me that this was at 6:10, that he was going to be another 30 minutes late. And at that time I said, okay, can you call him and tell him that we have to go because he's running around the parking lot and I can't keep him in the car. And I was afraid he was going to get run over. And I couldn't control him. So she called him and told him that. And then apparently, even though he had said he was going to be another 30 minutes late, he's claiming that he was there 10 minutes later. So he's saying that he was there at 6:20. In addition, I was about 15 minutes early, so I'd been there for quite some time. The rude and disrespectful language was coming from both sides. I don't understand how he can tell me that I'm a bad mother, I'm a neglectful mother, I should be in jail, and then me say something that's not completely in line, and then only me be held accountable for it as far as contempt goes. And just to reiterate, I didn't mean to commit any contempt. None of it was willful. I was just in a stressful situation. I was overwhelmed.
Mr. Do you have a recollection or any evidence to demonstrate that his call to you that day when you were running late was from a phone other than the Mavericks phone?
I believe it was from the Maverick phone. She called me from twice.
Okay. So she was able to call you, but not from her mom's phone.
At that point, yes.
Okay. And sir, I know that the back and forth between the two of you has been very difficult. Did you engage in anything that was disrespectful? For example, denigrating Ms. parenting or herself as a parent during that conversation?
Not for sure. And I, at times, can have tone issues or direct statements, but I don't remember using any curse words, any kind of offensive language.
Okay.
May I just add a couple of things,
Now-
Your Honor, real quick?
I was coming back to you, Mr. Meador.
Thank you. I think that the way that Mr. communicates with Ms. She certainly hears those things, whether he uses those exact words or not. But to the best of my knowledge, they weren't in the communications involving this specific event. I think she's probably talking about some other communications where he's used such language. The information that was provided to me was the exchange was scheduled for 6. She left at 6:15 saying she had been waiting for 45 minutes. So that means she was there at 5:30, which led me to believe that there was ample time to try and find the phone. And then beyond that, the information provided to me showed that after she left, the phone was immediately available to her, but she couldn't remember when or where she found it. That's what troubled me about that part of the story. The communications showed that Mr. was there by 6:20, which would have been 20 minutes after the appointed hour and not a half hour after 6:15. The problem I again have is I've repeatedly, consistently told both parties that if they're going to bring matters to me, it cannot be based on what they claim their daughter says. I don't want her in that position.
Is there anything else that you would like to say, ma'am?
Just that, I mean, I gave a general timeline, the best that I recollect. Everything that I said was true. If you have any more questions, I mean, I can answer them if it helps clarify, but everything that I said was true. I wasn't making any stories up. With the phone, I found it when one of my children found it when I got home. I didn't ask them where they found it. So I wasn't exactly aware where I found it. But it was not immediately after I left. It was when I had arrived home when the phone was found.
All right.
So-
Mr. Mr. Meadow, go ahead.
No, go ahead. Now, I was just before we move on to the next part, I had a couple of days ago, I reached out to the parties and said that, if you guys are doing well, I mean, I'm not hearing from you. I'm hoping that means you're doing better. I'm open-minded to asking the court to hold things in abeyance so long as you do well, so that we encourage doing well rather than encourage or focus on punishment. And it's at that point that Mr. raised concerns about Mr. Holt and dynamics that aren't really relevant to this hearing, but are relevant to their daughter's life. If the parties are engaging in counseling, co-parenting counseling, and are committed to continue to remain in co-parenting counseling, that would certainly make me happy.
And I would guess if they are in counseling and committed to doing the work necessary to try and do some repair to their co-parenting relationship, what I'm understanding is that the sanctions against Mr. in recommendation number 17 and the request for contempt against Ms. would both be held in abeyance?
Yes, Your Honor. I would note that the pendulum has swung and Mr. communications with me are now quite obsequious.
Well,
But that's better.
I read them as well. They were certainly respectful. Here's what I'm going to do. I'm in line with Mr. Meadow. I don't think that having punishment be part of your relationship with the parenting coordinator, I don't find that to be a terribly useful exercise. However, it is very important to know that disrespectful language isn't just cursing. It isn't just using vile language. It is saying bad things about the other person, including their parenting style and their status as a parent. None of that is acceptable, and it is certainly not acceptable around. Should not be asked at any time to be the go-between or the intermediary between her parents. I understand that you were probably trying to deal with another child and were asking for his assistance. However, when it comes to having to talk to Mr. relate information to you that you may not like, and then relate information back from you to him, that is unfair to her. It puts her in the middle, and it is, of all the things that we've talked about today, the thing that gives me the greatest amount of concern. If that happens again, contempt is in your future. No ifs, ands, or buts. Is to remain out of the middle in any way possible. And that means you're going to have to think about that a bit, ma'am, because you were in contempt of recommendation number 2 when you asked to talk to her father. With regard to recommendation number 1, that is also problematic, ma'am. It is the two of you have difficulty at the exchanges. You yourself have been late. Mr. has been late, it is imperative that you have your phone with you so that you can know whether Mr. is going to be there at the appointed time or not. And you should also know that just because you got there early, and so we're there for a total of potentially 45 minutes, that half an hour that you were there early is not held against Mr. He didn't need to get there early. You got there early. So you weren't waiting for 45 minutes. You were waiting for 15. And you left at that point without having checked our family wizard. That is also a problem. I am pleased to hear that whatever happened with the communication with the therapist has been resolved and that continues in therapy, and that therapy was uninterrupted by the odd text message. And so that's a good thing, and really is kind of a no harm, no foul kind of situation. Ms. I believe that you have committed contempt. I believe that number one, there are orders approving those recommendations, that the recommendations themselves are clear and capable of being understood. If they were not, the court would not have approved them. And number three, I believe that you are capable of complying with all of those recommendations. And so while there is a finding of contempt with regard to those matters, I am holding any sanction with regard to that contempt in abeyance. Mr. In recommendation number 17, Mr. Meador has suggested small, moderate sanctions against you for various conduct. I am holding those sanctions in abeyance. And they will be held in abeyance, and the court will not order that either one of you have consequences so long as you continue to go to co-parenting therapy, so long as you continue to work together positively in the best interest of your child, and so long as there aren't additional problems brought to Mr. Meador. If there are additional problems brought to Mr. Meador and the court finds that one or the other party is substantially to blame for the discourse and the problem between the parties, I may lift the abeyance and award either the contempt sanctions or the sanctions against at that time. I remind the parties that Mr. Meador also has the ability, if he believes that one party or the other has not brought an issue to him in good faith, he has the ability to shift fees so that one party or the other pays a greater or lesser amount of the fees for that particular circumstance. I am pleased that you haven't had to reach out to Mr. Meador recently. That is a hopeful sign, and I am hopeful that co-parenting therapy is working for you. And so at this point, as I said, I'm holding the sanctions on both things in abeyance, and hopefully we will not have to have them levied in the future. Anything further from you, Mr. Meador?
Not directly related to 17, but that has come up in the communications between Mr. and myself, and that is his concern about his well-being arising out of the alleged domestic violence, and his reference to the perpetrator of that violence as boyfriend. This is not an issue that's been brought to me. I haven't done the investigation, but the allegations of domestic violence are presented as being very serious, and there is a court order for not be in Mr. Holt's presence, and I just think it might bear on you and me having a little bit better understanding of what actually is going on and whether is getting appropriate support from her therapist about that right now. I don't have an opinion. I don't know enough facts. I have concerns.
I have concerns as well, and I have concerns on both sides. It is of concern to the court that a victim of domestic violence is having that circumstance used against them as a sword in a custody dispute. That's problem number one. I don't like a victim to be re-victimized. Problem number two is there are constraints with regard to Mr. Holt, and I am concerned about whether the alleged domestic violence is something that occurred in the past or whether it's something that is occurring in the present. And I would say that if it's occurring in the present, then while I have severe reservations about victimizing someone who's already a victim, I also have to say that it's really important that he is safeguarded and that protective capacity of a mother for a child is something that comes into play. Other than those comments, I don't have any further facts to be able to say anything either.
Your Honor, is the therapist aware of the dynamics and working with her about it?
Mr. You know?
My
Yes, go ahead.
understanding, I apologize, Your Honor. My understanding is talking about her ongoing issues with her therapist. She does go bi-weekly. To my knowledge, she goes every other week on my time on Wednesdays. And starting as of the next custodial change back to me, it'll begin one Wednesday every month, and every other Friday is going to be the change.
Okay, Mr. I think the question was more pointed, and the question is his therapist aware of any allegations of domestic violence in her mother's home?
I believe so, yes.
Okay. Ms. Same question to you. Do you know if his therapist knows of any circumstances that would cause her concern with regard to acts in your home?
I'm sorry, can you say that one more time?
I can, and I may not have asked that question artfully. I apologize. Have you talked to his therapist about any potential domestic violence that he may have witnessed?
She did not witness anything. She wasn't there, and the only reason she knows is because and Antonia have talked to her about it. Otherwise, she wouldn't even know that it had happened. I have not talked to her therapist about what she was told, though.
Okay. So was not in your home when anything occurred?
She's not allowed around Zachary Holt. She hasn't seen him in years. No, she was not. She didn't.
Okay.
Not.
All right. Do you think, how would are there acts of domestic violence that are occurring presently, or are these things from the past?
Recently, not in the past. It's happened in the past. It's happened recently. It's not happening right now. She was
okay.
In the protective order. I have a no contact order. I have an EPO. In the EPO, it does state that he's not allowed to be around the children that I have with other fathers, including that does address her as well.
Okay. And but you do share a child in common, so there's something occurring where there's visitation?
Yes, he picks our kids up on Friday and then brings them from school, then brings them back to school. And that's it, every other week.
Okay. Okay. And that's okay according to the EPO that you have.
That's what the EPO states that he's allowed to have.
Okay. All right. Then Mr. Meador, I think we know what the parameters are. It isn't that Ms. Can't be around Mr. Holt because they do have children in common. Although she has to right now deal with the constraints of the EPO, it is that he may not be in Mr. Holt's presence.
Right, and perhaps I was misreading Mr. emails where he expressed great angst about the stress he is under due to this situation. If it's true that she's only aware of this situation because he told her.
And Mr. talked about this before. You are not to be talking about circumstances that occur in his home. If he has angst about her mother being a potential victim of domestic violence and she isn't there to witness it, the only way that angst happens is if you tell her, which is inappropriate. That needs to stop if it's going on.
Understood, Your Honor. One other factor to that is it creates animosity with when she brings those issues to me, saying that she's heard them from her siblings when she's gone back over there and other sources. It's not myself that's presenting this information to her. And it creates a barrier between her and I on our communication if she can't come to me with how she's feeling. So I suggest to her to go to her therapist, of course, but it creates issues within because she's being torn by other means than just myself.
Well, and I think that it's really important that you guide her to her therapist because that's what her therapist is there for, is to help her sort those feelings out.
Yes, ma'am.
I mean, you can be supportive, but be supportive by saying, look, this is really one of the things you need to talk to your therapist about. All right. Mr. Meador, anything further?
Nothing, Your Honor.
All right, thank you so much. Then, as I said, this matter, both the contempt sanctions and the actual sanctions awarded in recommendation number 17 are held in abeyance, and hopefully we will not need a recommendation number 18. This matter is in recess. Thank you, everyone.